Good afternoon,
Good
Your Honor.
afternoon. This is from the mobile law office of Cirillo Martinez. You're here at the right time and date for this motion. I expect the prosecutor to log in here momentarily. We are already on the Zoom YouTube. Turn the record on here. I understand Ms. Deborah Davis will be coming in for this prosecutor. Here comes Ms. Davis now. I'm not sure how much you can see with a phone. I don't know if you only see the side of my head.
See her messing with her hair.
Hey.
All right, so you see who's speaking, and with me, when you're speaking, you see the sideways shot instead of my head-on shot.
I've got four views here.
Screens. All right, and you got what we've got. Anyway, we're all here except for the defendant. We'll address that momentarily. This is entitled State of Michigan versus Guadalupe Salvador Villafuerte Ferrar. He is represented by attorney Cirillo Martinez, who is present, and the people are represented by Assistant Prosecuting Attorney Deborah Davis. The defendant is charged with child abuse in the second degree. Let me get to the complaint here. It is alleged that on or about November 2nd of 2020 that he did commit an act that posed an unreasonable risk of harm or physical injury to a child. In fact, did result in physical harm to that child. The child left unsupervised, resulting in a skull fracture. That is a felony punishable by up to 2 years imprisonment. Defendant was arrested on that charge. In April of this year, arraigned at the jail on April 13th. A court-appointed counsel was appointed, and then Mr. Martinez was retained. Pre-exam conference was set for April 27th with a preliminary examination on May 4th. Mr. Martinez filed an appearance. The defendant was arrested on that very day, April 27th, by an immigration service held in Battle Creek. So the intention was to do the prelim by Polycom from the Calhoun County Jail. The pre-exam conference was set for May 11th. Then the defendant was transferred to the St. Clair County Jail. So the plans we made to try to do the prelim on the original date failed. Then we contacted the St. Clair County Jail on May 6th, and they indicated that he had been deported and was picked up by the Immigration Service on May 4th. So the pre-exam conference was set for May 11th, and the defendant did not appear because we were advised he had been deported. So the prosecutor, I don't remember who was there, whether it was Mr. David Marvin or Deborah Davis, requested a bench warrant for defendant's failure to appear at the pre-exam conference. Even though he was in custody and had been deported, their contention was there was a hearing, and through his failure to neglect, he was unable to appear for the hearing. So a bench warrant issued for his arrest and was set in the amount of $25,000 cash or surety will extradite from the United States, and that warrant is in effect. Then there was some email as exchanged where Mr. Martinez expressed concern about that, resulting in his filing of a motion to quash the bench warrant. And that was filed on June 17th. The matter was set for hearing today. The motion doesn't cite any authority, but it requests the court to quash the warrant paragraph 7. Mr. Villafuerte Ferrar would like to move forward with this matter from Mexico and clear his name from these allegations, as they are detrimental to his immigration petition filed by his mother. Mr. Villafuerte Ferrar would have complied with all court appearances but for being arrested by ICE prior to the case being finalized. Mr. Martinez, is that essentially your position here?
Yes, Your Honor.
Anything else you wish to say about it?
Well, Your Honor, I think that considering that these proceedings have been ongoing via Zoom, it would be feasible for this court to proceed this matter with a Zoom trial from even with Mr. Ferreira in Mexico.
Well, it didn't take much effort to say that, but it would take a whole lot of effort to do what you're saying. Well, here he is.
I believe he is joining the Zoom right now.
I wasn't aware he was going to be here. Facilitating a preliminary examination and or trial from another state is difficult. Presuming it from another country with the language barriers that exist would be even more difficult. Mr. Villafuerte Ferrari, can you hear me?
Your Honor, I see him, but yeah,
it's going to take a minute. I don't know what sort of facility he's in.
I believe he's in home in Mexico.
Oh, he's not incarcerated?
No, Your Honor, he was deported to Mexico.
Okay. All right. I misunderstood. I thought he was in some facility.
Oh, no, Your Honor. He was sent back to Mexico.
All right. Okay.
So he's not in a facility in Mexico. He's at home in Mexico.
And we're expressing some of the fundamental difficulty about just connecting. One says turn audio on. One says, I don't know if you can read it. This is backwards.
Your Honor, if I may, Salvador, ¿me escucha?
Sí.
There he is, Your Honor. I think with the assistance of a translator, we would be able to get the matter resolved, Your Honor.
I didn't realize he was going to be here, and I didn't realize we needed a translator. I would have made provision to have one present.
He's making himself available to the court, Your Honor, because...
Well, he has done that. Does he speak English?
Not much, Your Honor, no.
Well, I'm concerned that he isn't going to understand what we're doing here. Um, as I said, I didn't know he was going to be here. I'm pleased that he's here. I would have had a translator available. So we may have to take another crack at this. Deborah, what's your position?
Well, Your Honor, the motion did fail to cite any law or statute, court rule, anything in it other than they just want to get this resolved. Without the defendant being physically present here in the state or the United States for that matter, we don't really have a way to have any proper jurisdiction over him. If there is a decision made that the case should be bound over, we wouldn't be able to do a trial. Our court is open now, and honestly, I prefer that the defendants be here in person in the event there are bond violations or changes in the bond. This goes back to the fact that the defendant was here illegally, which is not any of our doing on the prosecution side. And it creates an issue with having to handle this case when he has not come into the United States appropriately. And now he's been deported. If he is able to come back here legally, then the bench warrant stands and he can deal with the case. I don't believe that it's appropriate to remove the bench warrant, and whether or not he's able to get back here legally, the concern is that he told the officers that he's been deported or taken back twice and he'll see us again. So we want the bench warrant in place in the event that he does make it to the United States.
Your Honor, if I may respond, the issue here is that even a pending case for child neglect or abuse under the Adam Walsh Act prohibits him from entering the United States lawfully. So that's the real issue here. The prosecutor can, if they wish, to dismiss the case and have the authority to refile at any moment. If they would do that, that would also obviously be acceptable. He's making himself available to the court. He can waive the jurisdictional authority of the court, if he may, or allow himself to the court to proceed with this matter, both district court and circuit court. So he would do that in order for him not to resolve this case, because a child abuse, like I said, or neglect case would be detrimental to his immigration petition that he's trying to move forward with.
Well, frankly, I think that's just what Mr. Marvin wanted. I can't speak for him, but the petition alleges this child had 8 broken ribs and a broken humerus in addition to the allegations alleged in the complaint proper. He's in a catch-22. He has a bench warrant for his arrest, which prohibits him from getting into the country. Ms. Davis says, well, if he wants to get here and come face the charge, he can do that. Well, the only way he can do it presently is unlawfully. He'd have to break the law to get here. And their concern was that he's done that once or more times to get here in the first place. So they wanted the warrant to be outstanding to prohibit him from coming into the country. And if he did come into the country, for him to be able to be arrested. But your position is the only way for him to come back and face these charges is to break the law. And, but I think the discretion is with the prosecutor. There's no authority that you've cited that says they can't do this. And Ms. Davis, your position is you don't wish to dismiss the charge or recall the bench warrant?
Correct.
I'm concerned about the hearing that we're doing because the defendant can't hear it. He can hear it, but he can't understand it, which is the tantamount to him not being here at all. The fact that he is here demonstrates that he is willing to make himself available to the court. But the true point of fact is he's charged with a very serious offense. He was in the country unlawfully at the time the offense was committed. The offense was apparently serious enough that the Immigration Service deported him. It would have been nice if they'd let us, they didn't, to my knowledge, they certainly didn't contact the court. Did they give any contact to either the defense or the prosecution?
No, Your Honor, they didn't give me any information. My understanding was that the immigration used a prior removal order that was issued, I believe, sometime. I think I had provided it to the court, but it was an old removal order that was reinstated. The issue with him coming back is that he will likely be not only prosecuted for reentry on federal law, but it would be obviously more detrimental to his immigration petition. So he doesn't want to violate any more immigration laws, but he doesn't really see a way of resolving this case other than allowing for this case to move forward.
That is the posture that it's in. I just had a case this week, a criminal sexual conduct case that was 7 years old. The prosecutor had held the warrant open for 7 years, and the defendant was in another state, the state of Illinois. He was in prison, and the rules are a little different when a defendant's in prison, but this warrant remained out for 7 years. The defendant did a detainer, and right now I'm still not sure how he got here, but he's in the custody of the Department of Corrections, and he got here to Michigan to deal with his 7-year-old criminal sexual conduct charge. The facts are very similar to this, except for the fact that your client's in Mexico, not in Illinois. The prosecutor has lodged the charge. They don't wish to dismiss it. They've requested a bench warrant. They don't wish to dismiss it. And you haven't cited any authority that compels me to order them to do that. And it's sort of a pocket veto. Under this set of circumstances, this case will never be tried. There's nothing that compels the court to do a Zoom trial from another country. And even if the defendant were convicted, the court wouldn't have any jurisdiction to sentence them. So your defendant's in a difficult position. You can obtain a disc of this and provide a copy to your client so you can translate what happened here. You can appeal my decision to the circuit court. But Ms. Davis, I'd ask the prosecution to prepare an order that states the defendant's motion to quash the bench warrant is denied.
We will do that, Your Honor.
Mr. Martinez, I think you have 21 days to appeal that.
Right, Your Honor.
Judge Stutson may have a different view of this, but it's a strange set of circumstances, and the defendant is between the proverbial rock and the hard place. All right, anything further we should place on the record here?
No, Your Honor, I will advise him of what transpired and see if he wants to proceed. I'll notify the court.
He's here right now. Do you wish to speak to him in a breakout room?
I certainly can, Your Honor. I appreciate that.
All right. Let me close this other one I've got going here. what is his current address?
Señor, ¿qué es su domicilio actual?
Aquí en México,
Sí.
calle Francisco Villa,
Ajá.
número 24, Colonia Revolución.
¿En qué ciudad?
Sinapecuaro, Michoacán.
¿Código postal?
Código postal. ¿Cuál es el código postal? Código postal, a ver, déjame.
Yo lo encuentro, pero no se preocupe.
Oh, está bien.
I can email the court or file.
That would be fine. Please email us that address.
I certainly will.
I'll put you guys in the breakout room, and when you're done, you can simply hang up.
I appreciate it.
You have an opportunity now through this connection to speak to him face to face. Ms.
Okay.
Davis, you have any further for us?
No, Your Honor. How would you like us to submit that order? Do you want it as a 7-day?
No, just submit it and I'll sign it and share it.
Thank you.
Thank you, Your Honor.
All right. All right, that finishes our day as far as I can tell, as they bring us some last minute additional information, but we're going to close out our live feed. Be ready to begin